Do you know that except the northeastern states and a southern state of Kerala, every other state in India has some other law which bans beef consumption or cow slaughtering. This last year, 2021, the Assam government also passed its cattle prohibition bill, where basically beef ban or cow slaughtering has been banned in 5 kilometer radius of temples and satras and certain other Hindu dominated places. So, have you ever wondered whether this banning of cow slaughtering is legal or is it illegal? What does the constitution have to say about it? What is the legality of Indian uh, territory talks about it? This is something that we'll try to understand in this particular video. I welcome you all to the session, and I would like to begin this session by a simple understanding of fundamental rights, DPSPs, and the legality behind certain conflicts that binds them. So before understanding that conflict or the more popular recent current affairs topics, we have to understand what are fundamental rights basically. So firstly, I would like to tell you that fundamental rights are certain basic human rights or certain provisions that various constitutions of the world ensures its people that allows you to save yourself from the exploitation and encroachment of the states. Often at times I describe it as just a limitation on the state's power. What do I mean by state? Here state means all those entities that is covered by Article 12 Indian Constitution. It is there in the part 3 of the Indian Constitution and also referred to as the Magna Carta of the Indian Constitution often at times. But talking of its origins, as you can see here, Magna Carta of the Charter of Rights issued by King John of England in the back then times of 1215 was the first written document relating to the fundamental rights of citizens. If we have to move forward understanding DPSPs, what is the relation of DPSPs with it? Now DPSPs is something totally different. DPSP has to do something with the principles that governs the state's policy. Principles, these are certain principles, basically directive principles. These are some principles or guidelines here which basically tells the state or the legislature to enact laws on it, to devise its policies on it. These are basic guidelines. For example, our parents feed us with various guidelines that we should come home before 7 p.m., we should not eat too much of junk food. So these are certain similar way, these are certain guidelines for the parliamentarians, for the government to follow and devise its state policies based on it, right? This is again in the part 4 of the Indian Constitution, and this has something to do with the Spanish Constitution. The original provision was there in the Spanish Constitution, then it came to the Irish Constitution, and from the 45th article of the Irish Constitution, India also tries to copy it. So again, summing up, fundamental rights is for the citizens, DPSPs are for the state. It is a limitation, fundamental right is a limitation on the state. DPSPs is a limitation on the government, which talks them as a guidelines. It tells them that this is the thing that you should do. For example, organization of village panchayats. For example, giving free legal aid. For example, making provisions for educational opportunities. Now, the problem here is that we get to see that in the attempt of provisioning or in the attempt of providing Indian citizens with certain rights, we often at times happen to counter certain DPSPs, to counter certain provisions which are guidelines for the state to formulate their policies on. What are these problems? What are the differences? Let us try to see. Now, starting of the debate starts here, like unlike fundamental rights, the scope of DPSP is limitless. What does this mean? Basically, it protects the rights of citizen and work at macro level, because all our policies are formulated in the parliament, right? So if the parliament has to do an amendment or a change in the legislation, the scope of it is limitless. DPSPs consist of all ideas which the state should follow and keep in mind while formulating its policies and enacting laws in the country. Now here this particular thing, the particular conflict comes here. The Article 47 versus Article 21. Now Article 47 says of the Indian Constitution, as you know, it bans the intake of certain drinks and drugs, which is injurious to your health basically. The DPSP says that you should not have alcohol, you should not have drinks and drugs. Article 21, which is a fundamental right now, goes on to say that every person has a right to life and personal liberty. Now, because of your personal liberty, you can say that alcohol consumption is my freedom and I want to have it. Now, which one do you follow? Do you understand? The part 3 of the Indian Constitution is in a conflict with the part 4 of the Indian Constitution, of the same Constitution. Another example, we take the example of Article 48. Article 48 now tells you that there should be a ban on the slaughtering of various cattle. We should not ban cattle basically. Okay, it's a Gandhian principle. Now, if we compare it with Article 25 fundamental rights, it's giving you freedom to practice, propagate and profess your own religion. Now, you know that eating beef is practically thought of Islamic practice, and Islam, people of Islamic religion or the Christian religion, these people are not having any bindings on consumption of beef. Again, we get to see an example where fundamental rights and DPSPs are not going hand in hand. DPSP is saying ban this particular practice, fundamental right is saying go forward and do this practice. Another example, if we have to take the example of Article 44, Uniform Civil Code. Now, Uniform Civil Code is something which is giving us a same code in the civil matters of all the religions. But currently in India, as you know, Hindu have different acts which governs their marriages, divorces, or property inheritances, child inheritances, alimonies, right? All these kinds of things के लिए Hindus have different laws. Muslim follows the Sharia law. Hindu follows the Hindu Personal Laws Act. Christians have their own biblical laws. So all these kind of things is giving the freedom again by the Article 25 to practice, propagate and profess your own religious practices. But Article 44 of the DPSP talks about having a uniform practice. So DPSP is saying that make it same for all, same for all. But fundamental rights is saying ki make it individual to all, like everyone is free to have their own practices by the medium of Article 25. Which one do you follow? In case of such conflicts, which one do you follow? Now that is one of the problems. Next, the directive principles are affirmative directions. On the other hand, fundamental rights are negative or prohibitive to the state. This is something that you already understood. Next, we have not discussed this. DPSPs are non-enforceable by law. That is, you don't have a protection in the court of law if there is a violation of the directive principles. But if the fundamental rights are violated, you can directly approach the Supreme Court. Supreme Court has an original jurisdiction in the case of fundamental rights. So these are some of the conflicts. Now let us see what the Supreme Court or the various historical judgments has to say in the case of a conflict in these matters. The first judgment that we have to discuss here is the historical judgment of Champakam Durai Rajan versus the state of Madras. Now this is a judgment in the times of 1951. In this case, the Supreme Court ruled that in case of any conflict between fundamental rights and DPSPs, the former would prevail. That means the fundamental rights would prevail over the DPSPs. That is, on any given day, FRs are greater than DPSPs. Let's say the DPSP says there is no cattle ban. There is a cattle ban, and fundamental rights says there is no cattle ban. There is no cattle ban because fundamental rights would prevail. Next, it declared that directive principles have to conform to and run as a subsidiary to the fundamental rights. Again, saying the same thing, that fundamental rights it's a substitute, it's a subsidiary, it runs behind it. It also held that fundamental rights could be amended by the parliament by enacting constitutional amendments. Fundamental rights can be amended. This was your Champakam Durai Rajan case. Next case that we have to see is the Golok Nath case. In this case, the Supreme Court declared that fundamental rights could not be amended by the Parliament even for the implementation of DPSPs. Now, in this case, Supreme Court reverses its stance. It gives some importance to DPSPs over the fundamental rights. Supreme Court has this power to review its own judgment, as you know, and here DPSPs are given a little bit of primacy. It is saying fundamental rights को आप amend नहीं कर सकते. You cannot amend the fundamental rights to implement the DPSPs. It was contradictory to its own judgment in the Shankari Prasad case. In the Shankari Prasad case, basically Supreme Court reversed its stance. It said that DPSPs are more important and fundamental rights can be amended. Here, Golok Nath says that fundamental rights cannot be amended. Again, supremacy to the fundamental rights. Keshavanand Bharati case, landmark judgment of 1973. The Supreme Court overruled its Golok Nath case verdict and declared Parliament can amend any part of the Constitution. Any part means fundamental rights also. Again, there is a shift of the judgment in Supreme Court. Supreme Court says that now you can amend fundamental rights. In Golok Nath, it said fundamental rights cannot be amended. Supreme Court now says, 1973, that you can amend, but provided it does not violate your basic structure. Your basic structure, some basic features of the Constitution, if they are not violating, this amendment is not violating, then your amendment is acceptable in the court of law. Now, you might have been confused seeing all these mood swings of the Supreme Court time and again changing this. All of these comes to an end in the year of 1980, where we get to see the final verdict, and that is a permanent verdict as of now as well, the verdict of Minerva Mills case. 1980 Minerva Mills case. It permanently made DPSPs subordinate to fundamental rights. That is, fundamental rights on any given day is more important than your DPSP. Always. Supreme Court also held that Indian Constitution is founded on the bedrock of balance between the fundamental rights and directive principles. It means that even though Supreme Court has given primacy to fundamental rights, it does not mean that DPSP and fundamental rights should always be in conflict. Constitution of India always should try. Parliament of India and the Constitution is made to make DPSPs and fundamental rights go hand in hand. That means Parliament should try to make such amendments, such policies to implement the DPSPs. However, not violating the fundamental rights of the citizens. That is what the final stance of the court says, and it should be balanced. And as we can see, many DPSPs have been implemented. For example, the Environment Protection Acts, the Water Act, or the National Honours Act, or the free legal aid that has been given, or the right to education, Article 21A, or the Panchayati Raj Institution 73rd, 74th Amendment. All of these were DPSPs at one point of time, now is a legislation. And similarly, but if in case there is any violation of the fundamental right, it has to prevail over the DPSPs. That is what the current stance is. Summarizing the entire thing, fundamental rights, basic human rights, DPSPs, guidelines for the government. Both are important in their own places, but sometimes they violate, for example, Article 47 with Article 21 or Article 44 with Article 25. These violations may, what is the current stance of the government or the Supreme Court? That fundamental rights would prevail over the DPSPs. That is what you have to write in your mains answers. And the last judgment, Minerva Mills case, can fetch you some extra marks. Hope you have gained some knowledge about this topic of conflict.
Borthakur IAS Academy. প্রস্তুতি আর অধ্যয়নৰ নিৰ্ভৰযোগ্য ঠিকনা। Borthakur IAS Academy.